Supreme Court of India Darshan Singh versus State of Punjab, decided on January 4, 2024, SCC, online SC 17 facts of the case. The deceased, Amrit Kaur, was married to Darshan Singh, the appellant, sometime in 1988. Their marital relationship was strained owing largely to the fact that Darshan Singh had developed an illicit partnership with Ronnie Kaur, accused number 2, on the intervening night of 18 May 1999 and 19 May 1999. Darshan Singh and Ronnie Kaur, with the motive of eliminating the deceased, administered poison and intentionally caused the death of Amrit Kaur. The trial court convicted both the accused persons for the offense under Section 302 read with Section 34 and sentenced them to undergo imprisonment for life. High Court has upheld the order of conviction and sentence as against Darshan Singh, the appellant, and has allowed the appeal of Ronnie Kaur. Findings of the court: there is no eyewitness to the incident. The case of the prosecution rests on circumstantial evidence. The presence of the appellant and Ronnie Kaur in the appellant's house in the intervening night of 18 May 1999 and 19 May 1999 has been firmly and cogently established. According to us, the answer must be in the negative. There are several omissions that have been brought out in the cross-examination of prosecution witness 3 and prosecution witness 4, which seriously dent the credibility of their testimony. Prosecution witness 5 is a chance witness, therefore, it is not safe to rely on this testimony solely to prove that the appellant was escaping along with Ronnie Kaur after having murdered his wife. There appears to be no dispute as to the fact that the death was caused by poisoning. In fact, in his 313 statement, even the appellant states that the deceased consumed poison, aluminum phosphide, and committed suicide. We find it doubtful that the deceased would have been made to consume tea deceitfully given the nature of the substance. Forceful administration of this substance also seems doubtful since there are no injury marks suggestive of a scuffle. There was alive a strong hypothesis that the deceased had committed suicide, which explanation was led by the appellant in his statement under Section 313 CRPC, and it is sufficient to create a doubt in our minds. The evidence qua other circumstances sought to be proved by the prosecution, since the failure to prove a single circumstance cogently can cause a snap in the chain of circumstances. There cannot be a gap in the chain of circumstances. When the conviction is to be based on circumstantial evidence solely, then there should not be any snap in the chain of circumstances. If there is a snap in the chain, the accused is entitled to benefit of doubt. If some of the circumstances in the chain can be explained by any other reasonable hypothesis, then also the accused is entitled to the benefit of doubt. Appeal is allowed.